This is Reasonable Doubt with your hosts, Mark Garrigus and Gary Smith.
Gary, happy Sunday. Welcome to the 3-day weekend version of the Altar of Bard on a Sunday morning. You know, I think I ought to start putting on my Sunday best. You know, I'm going to dress it up here since we had quite a week last week, and maybe we'll continue it this week. What do you think?
Well, we'll forgive you for the 3-day weekend, but Mark, here's a stat that I didn't prepare you for that's a little shocking. Welcome to the 400th episode of Reasonable Doubt. Now, if you count the bards, it's closer to 600, and it's all, you know, about how you classify them. But the way that we've done it and the way that I number them, this is episode 400 of Reasonable Doubt, and a hat tip to our good friend and colleague Adam Carolla, without whom none of this would be possible. But that's quite a milestone to reach on Labor Day weekend 2023. Boy,
you're not kidding. In fact, I probably will run into Adam any moment here, so I will tell him, and he's anxiously awaiting his triumphant return. So,
well, I'm sure that will be sooner than later. He knows that he is always welcome here, and soon enough, something will catch his ire where he will come screaming at us, whether we like it or not. So we look forward to that.
Yeah, I love the drop-ins on ACS, so I can't lie. It's I miss him, and but you're holding down the fort, Gary, and it's good to see you.
You as well, Mark. How's it going this weekend?
Well, I will tell you, we have a couple of clips that, for those who were watching last week, it was a little frustrating to hear, we had played the hearing, which, by the way, if you're going to weigh in on that subject, at least watch the hearing and what actually happened.
Yeah, you can go to my Twitter if you're interested. One of the more recent retweets that I put up is the judge who was presiding over the initial hearing with Harrison Floyd, is who you're talking about, the one defendant out of Georgia in the RICO case who was denied bail.
Right, after getting on an airplane, flying to Georgia, and because he had the temerity to also be the only male of color. I think that there's another defendant, the erstwhile publicist for Kanye, right?
Yeah, right. That was misreported. It was reported widely that he was the only defendant of color, but that was
which is not true.
Right.
Which is not true. But if you listen to that hearing, you have a judge who was sitting there saying, it's not a bail hearing, but I'm going to tell you why I'm not going to give you bail, because you're a flight risk, even though you got on an airplane and flew here of your own accord, and because you have a record, even though he didn't have a record. The case was rejected by the DA's office. Then the feds picked it up, but only as a misdemeanor. I also saw some people backpedaling so fast that they were trying to say this guy that he really wasn't being prosecuted, and that he was some kind of a secret agent or something, because they couldn't find it on the docket. And it's infuriating, because what they were talking about, it wasn't a felony. All of these people had assumed that the prior assault on a federal officer, which was basically he was telling a guy to get out of his face, was a misdemeanor, which would not have been where they were showing when they went to look at it. They were looking for a felony. It wasn't there because it wasn't a felony.
And let me point out, he wasn't prosecuted felony or misdemeanor. These are still pending charges that have to do with the case in question that he is in court for at the time of the hearing. It's absolutely ludicrous. And for anyone who doesn't know what we're talking about, I encourage you to go to our YouTube channel, youtube.com/Reasonable Doubt Podcast, and go to our most recent episode, because it's 27 minutes of Mark and I yelling at each other.
Well, interspersed
rightfully so.
Right. And interspersed with a court hearing that is enough to drive somebody to distraction if you watch it, because the schizophrenic nature of that proceeding was something I've never seen. Speaking of schizophrenic nature, we have a couple of clips today.
Sorry. Yes, we do. I was locking my door there so we don't get a visit from a 4-year-old. We have 2 different clips, both of which are from news shows. One of them is Jen Psaki and the other is Rachel Maddow. Do you have a preference where we start?
Dealer's choice. You're curated.
Here we go.
That's very nice of them. That's very kind of them. I'd like to know one defense lawyer in the United States that's going to rely on a government's proposal of key documents.
Hey, by the way, he's absolutely 1,000% correct. She's mocking him. I understand she's mocking him, but name me one defense lawyer who's going to say, oh, yeah, I'm going to go to trial or I'm going to prepare my case based on the documents that the government selectively provides to me. But when it's being presented here as news, it's mocking Lauro as if he's saying something that is so over the top.
Right. And correct me if I'm wrong, but I don't know if it's in this video particularly, but I believe that there's over 1 million pieces of paper, 1 million documents that have been produced in this case.
I think there are terabytes. I remember 16 years ago, the first time electronic discovery was provided to me in federal court, and they said there's 4 terabytes of information. And I couldn't even figure out how big a terabyte was, but that is what we're talking about here. To set the stage, Lauro is representing the erstwhile president in the proceedings that are in Washington, D.C., and that's what she's talking about.
All right, before we get back to the clip.
And the person who's telling him to take the temperature down is the judge who's jamming him, and I mean jamming him on a case like this by setting the trial date for March of next year. Okay, we're in September, October, November, December, January, February, March. 6 months for a case that, by the way, you're going to keep in mind. I don't care where you are in the ideological spectrum. I could care less. But when you hear this presentation, remember something and see if it pops out to you, because it was the first thing that popped out to me. The government, the January 6th happened over 3 years ago. For those
closer to 4.
Remember. Correct. We're closer to 4 than we were to 3. Trump didn't sit on the case. The U.S. attorney who appointed midway through that period of time a special counsel. How long has the special counsel had the case? How long was the Department of Justice investigating this case? I would submit to you it's 10 times as long as Mr. Lauro has had discovery.
Yes, I couldn't agree more. And just because you called him the president there, I'm going to take a second to do a detour to the few people on social media who have said that they're annoyed by the fact that I refer to Trump as President Trump. I would refer to any president that way. That's the way you refer to people who have held that office, whatever you think of them. So shut up. All right. Sorry.
Well, by the way, I was talking about Bill Clinton earlier this morning, and I call him President Clinton.
Yes, I would call. I would call anyone who was held.
Reagan, I call Reagan President Reagan.
Exactly. That's how. I don't know. I mean, that's
when a judge retires, I still call him Your Honor or Her Honor, and I still call them Judge. I was in front of a retired judge, and called her just as recently as Friday.
Exactly, and that's how I would refer to a governor who is past or present. That's
by
how.
the way, look up the word honorific.
Yes, so, thank you. Okay, all right. Sorry, we've gotten 9 seconds into this clip, and you and I are yelling at each other. So let's go back to it.
Result of key documents. Judge, Mr. Lauro, as I said, let's take the temperature down. In the end, Judge Chutkan scheduled the trial for March 4th. Not of 2026, but of next year. The judge says, quote, the offense giving rise to this case occurred at the end of 2020 and the beginning of 2021. To propose trying this case over 5 years later risks the real danger that witnesses may become unavailable or their memories may fade. And while Mr. Trump has a right to time to prepare, the public has a right to a prompt and efficient resolution of this matter.
Hold on. Yeah, sorry. You go ahead. You can stop it. I was going to stop it anyways.
Because, by the way, this is not limited, however, so that you know, my complaint here has everything to do with what's happening here. But this always always is an issue that's raised in criminal defense. The government will sit, whether it's state or federal, they can sit on these cases until I've had cases where they filed. I've got one now pending in the office where they filed the day before the statute ran after 3 years, and then they want to immediately on your market set go start the case immediately. And then when you push them on it and say, well, why did you sit on this case? They say, well, we've got the burden of proof. All you got to do is create reasonable doubt. So therefore, you don't need as much time to prepare. As if the idea of finding and developing and investigating a case when you're on the defense, when you've got a bet the career, bet your life kind of case for all the marbles that you're going to somehow cut corners because all you have to do is raise reasonable doubt.
Yeah, it's just absolutely it's crazy. You know, at the risk of 5 years, we may lose witnesses. Well, whose fault is that?
Right. By the way, how much time has elapsed while the government sat on the case?
It defies logic. All right, let's keep going here.
This timeline does not move the case forward with the haste of the mob. The trial will start 3 years, 1 month, and 27 days after the events of January 6th, 2021.
Yeah, well, okay, so January 6th, 2021. So you take a look at that. It's going to start 3 years after. When was that case filed? How long after? Why don't we check the number of months and number of days from January 6, 2021 till 2023 as to when it was filed? It was well in excess of 2.5 years. If it was 2.5 years, sometime was clearly after 2.5 years. You're telling me that the government can spend 2.5 years investigating, putting together the case, but you've got roughly 6 months from the day that you get your discovery. That's fair?
Really hard to justify in my opinion.
And by the way, imagine it's not Trump. Imagine, I often say, because the only way sometimes you can break through for people to understand this, because when people come into my office and they want their first thing is, well, I don't understand this. How does this happen? Where are my rights? Blah, 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 blah. Say, you're one of the exact people when you ask that question who's out there screaming with the haste of the mob. You're voting for these kinds of fast track prosecutions. You're voting for the people who want the haste of the mob or supporting them. So how in the world can you now complain about it?
Yes, very well said.
So March 4th, jury selection begins. Here's one other thing that Judge Chutkan said today I think is worth noting and actually worth getting some advice about. The judge said today, quote, I realize that Mr. Trump's criminal case in New York is scheduled for trial on March 25th. I did speak briefly with Judge Merchan, the New York judge, to let him know that I was considering a date that might overlap with his trial. So she's explaining the two sides why she's picking this date, noting that it's up against the New York date, but she says she's spoken to the judge.
Okay, that's all. By the way, it isn't that interesting. Judges do that every day of the week. I can't tell you the number of times I'm sitting most recently in federal court out of state, and the judge, and I had alerted the judge that I had another state case, not with that current defendant, but with another defendant. And I gave the information, and the judge called and talked to that other judge. She acts like this is some unbelievable turn of events. That happens all the time. It's a judicial courtesy. So let's speaking of taking the temperature down, take down the temperature of the nonsense that you're spewing here that people are listening to.
Well, let's let it play out, because I believe she goes on to equate it to an air traffic controller. It's absolutely ludicrous.
I mean, Trump obviously has many trials coming up in the next year. There is that one in New York on dozens of state felony charges. There's also the classified documents trial in federal court in Florida. And prosecutors in those various cases may not themselves be talking to each other, but the judges apparently are talking to each other. Judge Chutkan saying in open court today that she has spoken to the judge, for example, in Trump's New York case, to give him a heads up, to help deconflict between at least those two trials. And while that might seem common sense, that's the first time we have seen anyone in any position of authority playing the role of air traffic controllers for all of these trials that are all going to be trying to land in the same year.
Okay, she's not playing air traffic controller for all of these trials. She is picking a date. Her Honor is picking a date which potentially conflicts with the New York date. She's not calling up Judge Cannon to say, wait a second, you got May 2024. They could talk. This is maybe the height of ludicrous nature, but this is a federal judge who takes precedence over a state case last time I looked. And that is normal operating procedure. What is not normal operating procedure is to pretend that this is just any other defendant, as opposed to a defendant who is the leading candidate for his party's nomination. And you're going to schedule trial for the, whatever it is, the date is March 4th, a Monday.
I believe so.
Is March 5th Super Tuesday?
Yeah, I know for sure that that's true.
Yeah. So of all the days on the calendar, this judge decides to start jury selection the day before Super Tuesday because she's going to treat this defendant like any other defendant. And all this does is give oxygen to everybody who's complaining that this is a political prosecution. So the way that you're going to avoid saying it's a political prosecution is to set jury selection for the candidate the day before Super Tuesday, which is traditionally thought of as the big prize, so to speak, in the presidential elections. And people wonder why there is polarization in this country and why people are saying that this is a political prosecution.
It sure seems theatrical.
It's a thought experiment I've done with Adam 100 times, and you've heard it, is there's 365 days in a year. If you threw a dart at the calendar for those 365 days, you mean to tell me that you would just randomly come up with the Monday before the Super Tuesday in a presidential election, and that there was no calculation, there was nothing there that was, I hadn't realized that. I hadn't thought about that, even though I've compared him to a professional athlete who has to play games. And by the way, that's treating somebody like another defendant, because professional athletes, if you've got to play a baseball or a basketball game, is the same thing as the next presidential election of the United States, who, by the way, the same person will be saying out of the other corner of their mouth that this is a fight for democracy. So spare me the bromides, because this really, I think, exposes the nonsense that we're talking about.
I couldn't agree more. All right, you want to check out our other clip we got this week?
Please.
Let's do it.
My head hurts from that one.
So, Neil, Andrew referenced this Mark Meadows trial. There's a lot happening tomorrow, actually. So let's start with the Mark Meadows.
His whole play, which is to try this in a place where he can just make up the facts in the law.
I think I might have the wrong edit here, but let's.
Well, it's okay, because that's perfect. His whole play where he can make up the facts in the law, if he's talking about Meadows. No, Meadows has a legitimate right to remove. There is a statute. It is used all the time where the case is removed from state court to federal court. Why this is ballyhooed or ballied about as if it's some kind of nonsensical motion that has no. And by the way, this is before, and I told you, Gary, to clip this, because I knew that a judge would give this serious consideration, and the way they were demeaning this whole thing was infuriating.
Yes. All right. Here, I think I've got the right edit point now. So let's go ahead and check back in.
Andrew referenced this Mark Meadows trial. There's a lot happening tomorrow, actually. So let's start with the Mark Meadows trial. He wants to move the venue from the state venue to a federal court. What are you watching for in this trial, and what happens exactly if any of these co-defendants who are asking for that are successful?
Yeah, so there's a really old law of Congress that says if you're a federal officer performing a federal function and you have a federal defense, if you've been indicted in state court, you can move that to federal court. It still means the state prosecutors control it all. So, for example, if Donald Trump wins in 24 or some other Republican, he can't terminate the state prosecution. But it does change things. So most importantly, and this is, I think, what Trump cares about the most, there are cameras in Georgia state courtrooms. There are not cameras in the federal system.
Do you think what Mark Meadows cares about?
Can we just talk about this? First of all, a really old law. I mean, what is a
really old law of Congress?
A really old law. I love that. I know what he's trying to do. He's trying to, it's some, nobody uses this. It's used every day in federal court and in state courts to remove, number one. Number two, no, I don't think this has anything to do with cameras in the courtroom. That is just rank speculation that makes no sense. And number three.
He's going to double down on it in a second, by the way.
Oh, yeah. And number three, remember, he's absolutely wrong. There is a method by which the prosecutor can get removed.
And by the way, I will point out to you, for anyone who watched this whole episode of Inside with Jen Psaki, where we've taken this clip from, he says the phrase really old law of Congress multiple times. I know, because when I was trying to find this clip, it screwed me up. I had him saying that, and I thought, okay, here's my clip.
Right. It's a really old law that has been utilized a really ton of times.
Yeah,
how's that?
Exactly. It's whatever. All right, here we go. Let's finish it up.
Cameras in the federal system.
Do you think what Mark Meadows cares about too?
Oh, absolutely. I think they all care about, they want this trial. They do not want the American public to see this trial. They are scared like vampires of sunlight here. And so I think that's part of it. Part of it is also to try and manipulate who's on the jury and things like that. So
manipulate who's on the jury. By the way, manipulate. Every law enforcement agency that removes a case to federal court. So now I'm going to start saying every time I've got a police shooting and it gets removed to federal court, Your Honor, I object. They're manipulating the jury because you get a larger jury pool in federal court than state court. And by the way, I'm going to venture to say that that gentleman, when he was acting Solicitor General, defended probably more than 100 times, his office probably defended cases involving law enforcement removing cases to federal court. To get up here now and pretend otherwise is the height of chutzpah.
Yes, absolutely. All right, let's finish it up.
Who's on the jury and things like that. So I don't think this removal motion that Meadows has filed is going to be successful because it does require you to be performing a federal function. And last time I checked, organizing a coup, even if you're the chief of staff to the president, isn't part of your official job
Right, and the chief of staff isn't typically calling the
Yeah. So guess what? That didn't age very well. And I had told you to grab it and I knew it wouldn't. Judge already issued an order finding that if one of the acts was enough, is that enough to remove it? Meaning if one of the acts that's alleged is in the course and scope of his duties as a chief of staff, is that enough to remove it? So this kind of facile red meat to whatever your audience is, that last time I checked, a coup is not in it. By the way, that last time I checked, prosecutors' allegations were squarely talking about his role as chief of staff. And I would venture to say that Mark Meadows is going to fight tooth and nail that he was trying to attempt a coup, as opposed to what his defense really is, if you want to be intellectually honest, which is he's going to say that he was doing the president's bidding because they had legitimate concerns about the election integrity.
But Mark, you're ruining such a fun soundbite.
It's just too much. It's infuriating. It's infuriating that there's no pushback, that you're just allowed to say these things without, well, wait a second here. By the way, do you think Jen Psaki's going to come back now and have him on as a guest and say, by the way, we did a little research. Why did you defend all of these cases in your office when you were in an official position, when they had removed their cases to federal court? By the way, it doesn't look like the judge is buying that this was a complete coup attempt, that he has already at least for purposes of the hypothetical, said that at least one of these acts was done in the course and scope of his chief of staff duties. So why? Why is it that we just can't have a discussion that actually is not clipping the corners here?
Well, since you asked, let's watch the last 10 seconds or so here, because I think it's interesting that you pointed out that she's probably not going to.
Isn't part of your official job
right, and the chief of staff isn't typically calling the Secretary of State of Georgia. As a non-lawyer, I can just state that as a person who's worked in politics.
Really? Well,
Great.
As a non-lawyer.
Wow, that's
the chief of staff is not calling a Georgia official. Really? How many times this week have you seen the president or the chief of staff calling state officials because of any kind or any number of emergencies that happen in Florida or Hawaii or somewhere else? The idea that somehow you do not call state officials if you're the federal, means that what did we have the Men in Black machine during COVID where the federal government was working with state governments? That happens every single hour of every single day. If you don't like it, I understand it. If you want to characterize it as trying to have a coup, I get it. But there is an argument on the other side. And if you're going to be intellectually honest, you're going to acknowledge that their argument that they're going to make is not that we are trying to do a coup. The argument is we were concerned with election integrity. We believe that there was interference in the election. You can say, I know what the response is. The response is, well, 60 courts looked at it, 60 courts rejected it. I get it. Does that mean you don't get to raise the issue when they're trying to, in a federal court or in a state court where the standard is beyond a reasonable doubt, which, by the way, is the highest standard we have in the law. It's not a civil case. It's not the burden of proof in a civil case. It's a much higher standard, which means that it may have failed in a civil context, but that doesn't mean that it necessarily or has any import whatsoever in a criminal context with a higher standard of proof.
Jewelry is having a big moment right now, and with hundreds of products popping up in your feed every day, it can be hard to find a brand you trust. Alex and Ani has been creating meaningful jewelry for over 20 years, designing pieces that connect you with all of life's important moments. With an emphasis on value, there's truly something for everyone. You might be most familiar with their signature charm bangle. This bracelet literally created the category of meaningful jewelry and had you stacking charms from your wrist to your elbow. This piece is an icon for a reason. Completely size inclusive, each bracelet is adorned with a symbol designed to tell your story and express your unique style. Beyond the bangle, you'll find stylish, affordable jewelry for every occasion, from classic pieces to bold statement looks. Don't know where to start? Alex and Ani makes it easy to unpack the trends you're after and sprinkle in your personality too. Each piece comes with a personalized message and meaning, truly making it the perfect gift. You can take comfort in knowing that you're shopping with a socially conscious brand as well. To date, Alex and Ani has donated over $60 million to nonprofits worldwide, connecting fashion and philanthropy in an easy, fun, affordable way. Visit alexandani.com right now to discover the confidence that comes with a perfectly accessorized piece of jewelry. Right now, Alex and Ani is offering our audience 20% off with code MIDAS at checkout. Again, head to alexandani.com. That's alexandani.com and use code MIDAS at checkout for 20% off your order.
Mark, I think we should leave it there. Thank you so much for your time. Happy Labor Day weekend, a great 400 and a great way to go out, I would say.
Thank you. Thank you, Gary. Happy 400.
Thank you, Mark. Have a great day and enjoy the rest of your long weekend. Bye-bye.
You got it. Bye-bye.
Thanks for listening to Reasonable Doubt. Subscribe on YouTube at youtube.com/Reasonable Doubt Podcast.